with one case, and I want to summarize it and to tell you why I think it is an interesting starting point to understand how Sharia was applied in 19th century Egypt. So it's a case that happened in 1876. It's a criminal case, it's not famous, it's a criminal case in a small village in the Nile Delta in 1876. A man, young man in his early 20s, is killed by the local strongman, a man called Hamad Zalat, who is related to the local village head. There's a land dispute, they have a fight, Hamad Zalat kills this guy, Muhammad Abdurrahman. And incidentally, this is what the records look like. These are the records I work with. So it's a lengthy report on what happened. Because the killer is a famous man in the village, when the victim's brother goes to report the case to the village head, he's advised not to press charges, to keep things silent, and to bury his brother in a clandestine way. The local barber surgeon is summoned, and he is forced and coaxed into issuing a basically forged death certificate stating that the cause of death is diarrhea. And basically they're intimidated, and the language, it says in Arabic, فَمِنْ خَوْفِهِمْ مِنَ الْمَشَايِخِ لَمْ أَمْكَنَهُمْ التَّوَجُّهِ لِلْحُكُومَةِ وَالتَّشَكُّلِ. Because they were intimidated by the sheikhs of the village, they could not go to report the case officially. The body was buried, and a heavy curtain of silence descended on the village, and that could have been the end of the story. Except a couple of days later, the local provincial governor of the whole province happened to be passing by. So encouraged by his presence, the brother steps forward and goes to him and tells him, by the way, 2 days ago, my brother was murdered, and because the murderer is a famous guy, no witnesses could step forward, they are intimidated. He pointed to where the body was buried. The provincial governor got very alarmed. He immediately summoned 2 doctors who came to the scene. They exhumed the body, and they conducted a post-mortem examination that says the following. There is a circular wound facing the bladder between the 6th and 7th ribs. Bloody, foamy substance had excreted from it. Its diameter is about 1 centimeter. Also, by checking the abdomen, a small circular wound was found. This wound reaches the stomach. From the above, it is clear that the wounds were caused by fine projectiles. These projectiles hit the left lung and the stomach, causing death. Interestingly, the report says these details, but suddenly they say that, encouraged by the fact that now there is these kinds of interrogations and investigations, the brother went to the Qadi court, the Sharia court in town, and he reported the case of murder. The Qadi, the judge, does what Qadis do. They asked him, what's your evidence? According to Islamic jurisprudence, evidence in murder case either is a confession by the defendant or 2 witnesses, by 2 male witnesses, 2 upright male witnesses to give a testimony, an oral testimony in front of the Qadi that have to agree on all important details. Now, as I said, there are no witnesses because people are intimidated and afraid, and the defendant did not give a confession. Accordingly, the judge could not find for the defendants, for the plaintiffs, and the case was closed as far as the Sharia is concerned. However, there are these parallel interrogations, and what we are reading in the case, in the file, is that the case goes to a majlis. Excuse my Egyptian pronunciation of Arabic, I'm not calling it majlis, I'm insisting on an Arabic pronunciation, a council. And this council rules on the case based on something called qanun, a qanun sultani, a sultanic code. A certain article is mentioned, and accordingly, and based on primarily the forensic medical expertise report, the defendant is sentenced to 7 years in prison. The case is forwarded to an appeals council, which upholds the previous council's verdict, and then it goes to a third council, a tertiary council, that upholds the previous two verdicts, and indeed Hamed Zalat, the murderer, is sent to prison for 7 years. Now, this is one case out of hundreds of cases that I read of what eventually I discovered to be an archive, an entire archive of ledgers like this that cover a 50-year period from the mid-1840s to the early 1880s. 45-year period of not one or two registers, thousands of registers, each one of them having about, on average, 100 cases, between 100 and 120 cases. We're talking about a huge volume of cases, not only criminal, but they can be land disputes. And they are all, the criminal cases have these kinds of details. And what I want to raise with you are the following questions. When I read this, I said, what is this forensic medicine? Where did it come from? We're talking 1857. Where are these doctors? Where were they trained? How were they trained? And how did they end up working in this judicial system? And what is this judicial system? These majlises, these councils. We know as historians, we know about the Sharia code registers. We've been reading the documents for the past 50 years. From Istanbul, from Damascus, from Beirut, from Cairo, all over the Ottoman Empire, thousands and thousands of registers of the Sharia code registers. But this is not Sharia code. These are something called majlises. What are these majlises, and what is this hierarchy of first, second, and then third majlises? And what is the connection that these councils had with Sharia? There is a Sharia code, but there is this majlis too. So what's the connection between them? How can we make sense of this? And I had a hunch early on that the key to answering this complex system is forensic medicine, is the embedded forensic medical report embedded in the middle of this lengthy police report. And I wanted to know how to tease it out. It took me about 15 years, so I have less than an hour to summarize to you my findings. So what I will do is first to zoom out of the case and to tell you something about the historiography of Egyptian law in the 19th century, what it is that we know, what we know about 19th century Egyptian law, and then I'll tell you how the received wisdom about this period has been challenged lately by some interesting revisionist historians, and then I will end with my own findings about from the National Archives of Egypt. So, put this here. Egyptian historians working on the history of Egyptian law in the 19th century have always, and these are the two most prominent historians, and you can Google them if you want, you can look up the numerous publications. But their argument is that the Egyptian legal system was basically borrowing from the West codes, legal codes and laws, but also the system of government, courts, and that ultimately it was there was an attempt to catch up with Western legal principles and legal practice, and this is how eventually Egyptian law became westernized. They are, in doing so, influenced by a canonical book, this book that I am showing here on the left, by Ahmed Fathi Zaghloul. Ahmed Fathi Zaghloul is a famous judge himself, and because of this book, a famous author. Those of you who know anything about Egyptian history, this is the brother of the very famous nationalist leader, Saad Zaghloul, who launched or was leader of the 1919 revolution, whose centenary anniversary we're celebrating these days, exactly these days, March and April of 1919. This guy's brother was the leader of that revolution back then. Not really interested in the brother, interested in this guy, and in this book in particular, in which he said that the 19th century Egyptian law was chaotic and not really legal because it wasn't properly legal. And what he had in mind is a Western, mostly French style legal system, and because there are these sharia business, for him this is really not proper law. So he dismissed it outright, and that set the pattern for historians who came after him to basically say that the culmination, the teleological end of the progression of Egyptian law is French law. And when they see Sharia in the middle, they basically think that this is something that had to be silenced, and eventually it was silenced. So they are, I think, influenced by him. Now, interestingly, the history of Egyptian law in the 19th century, believe it or not, is a highly charged topic. Politically, it's a highly charged topic. It is a highly charged topic because Islamists in Egypt write about it a lot. So let me share with you some accounts by Islamists, not academics, but big names in the Egyptian Islamist movement. And let me start by Abdul Qadir Auda. Auda is a famous judge who was tragically executed by Nasser, the president of Egypt, according to trumped-up charges in 1954. He was a judge in the Egyptian legal system. Late in life, in the 1940s, he joined the Muslim Brotherhood and became a leading figure in it. And because of that connection, he was executed in 1954. But importantly, he wrote this very, very important book that Islamists always quote in Egypt, and you can see the title in it. In it, he's making a comparison between his understanding. He taught himself Sharia. He was trained in a modern legal system, but he taught himself Sharia. And when he came to understand what Sharia is, he wrote this book and he says, what have we given up? We've given up a sublime, perfect, and complete legal system in exchange for something that is incomplete and imperfect and human, which is the positive law we have now. And he says, in my comparison, I'm not going to give you a historical account because there is no history to Sharia. Sharia was born complete. It's divine. And if you make an argument, he says, that Sharia started this way and bit by bit developed, then you will be assuming that it was born incomplete and imperfect. And that could not be true, because Sharia was inspired by God, and it is divine in its origins. So it is really it has no history, whereas Western positive law obviously did have a history. So there is for me as a historian, I cannot accept this. Sharia must have had a history, at least history of practice. Where is the history of practice? Where is the history in his account of the practice in Islamic law, in Islamic courts, in Sharia courts, down the centuries? We do not see this. There's a privileging of Islamic thought over legal practice, as we see in courts. And then we have, much later, a younger generation of Islamists. This, by the way, is what a Sharia court register typically looks like. I'll come back to this particular case later. But another very important Islamist is Tariq al-Bishri, who is a judge who's still alive. He's in his mid-80s. He's a famous judge, but he's also a historian. He writes prolifically on modern Egyptian history, and he too was not trained in Sharia. He too was trained in modern positive law in Egypt, and he too taught himself fiqh, jurisprudence, after the devastating 1967 defeat against Israel. Like many nationalists and many Egyptian leftists, they turned to Islam because of the defeat, trying to find an answer to why this defeat happened. Took him 10 years, and in the early 80s, 1980s, he started writing these very powerful, important and influential books about Islam in modern Egyptian life, including in modern Egyptian law. And he's saying, I have now come to realize how significant Sharia was. This is not something I was trained in law school, but this is something that I now realize how important it is. And he tells a very powerful story that has become a standard story in the way people write the history of what happened in the 19th century. The story is the following: that Egypt's ruler, we see him here on the right, Khaled Ismail, who ruled from 1863 to 1879, wanted a code. Sharia is not codified. The fiqh books are not codes. They are jurists' tomes, as they call it, a sea with no shores. Endless ruminations by jurists on various principles of law. And he said, this is very difficult to apply in a standard way in courts. He approached the jurists in Egypt of Al-Azhar, and he told them, I want you to codify law in one book so that we can apply it in courts the way the Ottomans are doing. And according to the story that Bishri is saying, that the ulama of Al-Azhar were afraid of doing this, and they did not answer this call because they were afraid of being accused of heresy. So, as a result, he turned to the guy on the left who, despite what looks like Oriental attire, this guy on the left is the quintessential Westernizer. Rifat Tahtawi is a translator. He was a member of a student mission sent to Paris in the early 1830s. And when he came back, he became a translator and founded a school of translation. This school translated French codes, maritime code, commercial code, constitutional code, criminal code, from French to Arabic. So Ismail then took the translated codes that Tahtawi had translated from French to Arabic And that is the origins of Egyptian law. And Bishri is making, in telling the story, a powerful critique of effectively the inauthentic, unoriginal sources of Egyptian law. Egyptian law used to be founded in sharia, but because of this encounter, what we ended up with is effectively French code in translation. And it's a very powerful critique of basically the Egyptian legal and political establishment for giving up on their heritage, on their origins, and of accepting and appropriating and borrowing French law, lock, stock, and barrel. There's a story about courts rather than legal codes that I will leave out because of lack of time. But I want to then stop at this very important, much later moment. In the 1970s, throughout the 1970s, the Muslim Brotherhood in Egypt and many other Islamists are making a call, like Bishri, of the need to go back to our sharia. The need to go back to our codes and to look at the existing Egyptian positive law and reform it, to revert it back to, and to make it compatible with sharia. This happens in Parliament, and the Parliament established committees, and the committees came up with this book that basically gave instructions to the government on how to pass new laws based on sharia and how to revise existing laws so that they become compatible with sharia. However, as the story goes, this book was put in the drawers. This became a catchphrase, sharia in the drawers, which means that there was a lack of political will on the part of the westernized elites of Egypt, and we end up with the continuation of an inauthentic Western borrowed legal system. And finally, I want to end this introductory part with what Dr. Alam mentioned, which is the 2011 moment. Because now there is an opening in Egypt in 2011, and this opening was appropriated or embraced by Islamists. This is a famous day, the 29th of July 2011, when various Islamist groups, the Muslim Brotherhood, but many Salafi groups, took to the streets, and their main rallying cry was, we want to implement Islamic Sharia, as this banner says, and so does this one. Now, I embraced, I mean, this is a picture, I did not take this picture, I have to admit, but I was there on that day, and I was very happy to see a very important constituency in Egypt that had been barred from the public sphere now participating so importantly and making their demands felt. I, as a historian, as I'm going to show you, have deep doubts about what this means. But still, I thought this is a very positive development. And I wrote an article, it's a silly picture of mine, but ignore it, and basically saying, what do you mean by implementing Sharia? Historically, how can we learn from history, which is what I want to share with you tonight, something that can inform our discussion about implementing Sharia. On the basis of this and numerous other articles that I was publishing, this is a daily newspaper in Egypt, I got an interesting invitation to participate, to appear on TV to talk about this in the wake of this big demonstration by Islamists. Because now there's a public debate. I thought, this is perfect. We need in Egypt a public debate on what it means to implement Sharia. So I immediately accepted the invitation to go to TV. Little did I know that when I stepped in the TV studio, that I'm not alone, that I have another interlocutor, another guest, who was supposed to be my interlocutor and we were supposed to discuss things. I said, okay, fine, but who is he or she? And he said, it is Tariq Zumur. Now, Tariq Zumur is not just any Islamist. This is Sadat's assassin. This is the guy who killed the president of Egypt in 1981. And he'd been in prison from 1981 to 2011. He'd been in prison for 30 years. He came out, he was released only a few weeks earlier, and taken to debate with me. I said, okay, let's discuss, this important topic. And I want to tell you what I could not tell him. And the reason I could not tell him is not because he was not interested. It's because the guy in the middle did not allow us to have a conversation. The guy in the middle is the anchor. But as we all know, anchors in Egyptian TV work for intelligence services. So rather than allow us to have a debate in which we will disagree, I mean, I do not agree with this guy, but he's Egyptian and we need to have a debate. And instead of having a debate, suddenly, in the middle of a very heated discussion, which I'm going to share with you, he asked him, excuse me, Mr. Tariq, but I want to ask a question that all our viewers must be asking now. Why did you kill Sadat? He said, what? And then all of a sudden, these screens behind us started playing videos of Sadat's assassination. In other words, it was staged. And he looked at me and I looked at him and I said, excuse me, we looked together to the anchor. I said, this is not why we're here. And this guy had paid his due to society. He spent 30 years in prison. Now we're here to discuss something else. But that is symptomatic of what the Egyptian state does. It prevents us from having meaningful discussions among literally adversaries. I do not buy what Zumur had done as an assassin, and I do not buy his vision of Islam. What I wanted to tell him, and I couldn't because of this abruption, is what I want to elaborate further on tonight, is the following, that typically the argument between secularists and Islamists in Egypt and elsewhere in the Muslim world is the following. Secularists tell Islamists, look, your argument about Sharia being divine is a bogus argument. It's untruthful, because we all know that Quran obviously is divine, but the interpretation of Quran, this thing we call Sharia, is human. It's men who acted through their intellect to produce these interpretations. And this is not divine, this is human. So let's disagree, but on our terrain. Do not use the divine card to stop our intellectual exchange. That's the typical argument. That's not mine. That's not what I want to share with you. My argument is different. My argument is not that we need to distinguish between Sharia as divine as opposed to Sharia as human, but my distinction is one between Sharia and fiqh. Fiqh in Arabic means jurisprudence. For me, Sharia is larger than fiqh. Fiqh is an intellectual exercise by the jurists. Sharia includes many other things, including what we will be talking about. Specifically, the kind of legal action in courts and in this thing called magalis. these councils? What are they? And how can we think of them as being part of Sharia? I have to say, in order to start the summary of the argument, is to introduce one last very important interlocutor, someone with whom I have been grappling for a long time. Talal Asad is, I think, familiar to some of you. He should be. A very famous anthropologist, but also critic of what he calls the secular project. Talal Asad and his students are very skeptical of this account of how law has been introduced that I was sharing with you a minute ago. For him, secularization is not simply the gradual appropriation of Western laws throughout the 19th century, so that by the end of the century, the realm of Sharia kept on being reduced and shrinking until it ends with what we now call personal status law: marriage, divorce, child custody, and so on. For him, this is a simplistic account of what really took place. For him, what actually captures secularization is the following. It is the divorce of law from morality. That by the end of the 19th century, we have a new field called law, which is not based on ethics. Whereas before then, the very principle of Sharia is that it is not only legal in our modern understanding of the word, but ethical. It's an ethical, moral project of individuals, of institutions, of societies. And by the end of the 19th century, Talal Asad is saying that this became an anathema, and all modern legal systems in the West, as much as in the Muslim world, had to separate ethics from law, and ethics became a private thing. And that private realm had to be itself constituted, protected, guarded, and policed. It's a violent separation. It's a violent divorce. So privacy is now the realm of the self, of the family, of the home, of the mosque or the church. But the state is not judged by ethics. It's judged by efficacy. It's judged by sovereignty. It's judged by power, and that has nothing to do with morality. And that is the crisis of secularism that Asad is critiquing. What Asad has in common with everybody else that I've been talking about, with Latifa Salim, with Muhammad Nur Farahat, with Ouda and Tariq al-Bishri, is an assumption that in a certain moment in history, supposedly before the onslaught of modernity, there was a moment in which law and morality were not divorced from each other. This is what Sharia was. Sharia was a system in which the state is absent, in which morality and the law were wedded to each other. So this is the set of, this took much longer than I wanted, but now you understand the kind of contours of the arguments that, and why this is an important question. It's important not only historically, it's important politically, and it's not only an Egyptian story. This can apply with variations in various other parts of the Muslim world. In India, in Indonesia, in Turkey, various other parts. Now, I'm a historian and I want to understand the history of legal practice, of what happened, like the case I started with, of Muhammad Abd al-Rahman in 1876. So luckily, I'm not alone, and I'm working specifically with these two men. These are pioneers of the history of Egyptian law, and indeed the history of criminal law in Islam. I met Hilal as a professor of history in Suez Canal University. He now teaches in Saudi Arabia. And Rudolf Peters on the right is a professor of Islamic law and Arab studies, emeritus. He's retired in the University of Amsterdam. You'll see a book by him later, but they are prolific, especially Rudolf Peters on the right. He has multiple articles. And what these people have done is to say, well, wait a minute, we have really not done our homework. Let us try and find out what actually happened on the ground using archival material. These two men are going to the archives, Egyptian archives, year after year after year, unearthing amazing new material. They're not reading the books of the fuqaha that are printed and published and housed in famous libraries. They are unearthing new material and shedding new light on new evidence. So, for example, they identified the laws, the actual codes. So this, for example, is the first criminal code passed by Mehmed Ali, the governor of Egypt, and it's passed in 1829 in Turkish rather than in Arabic. It's very significant because what are these codes? This is not French inspired. This is a local code inspired by Ottoman practice, based on Islamic principles. But interestingly, it's a law. It's called the Ottoman Qanun. It's not jurists' law. It is the state legislating, which is not our typical understanding of Islamic law. But here we have it. So he analyzes what does it actually say and how it is phrased. Then, like me, or I, like him, have been reading this huge archive of these ledgers of what they are called, of these megalis, of these councils. And the councils have a very weird name, and it's time to introduce the key term of this whole lecture, because they're called siyasi councils. In modern Arabic, siyasa means politics. So this would mean these are political councils, but they're not political, they're legal. So the question then is, what is this siyasa and what is its connection to sharia? They also worked on police records. You know, before the case goes to the Majlis, it goes to the police. And so let me try and tie in and start moving towards some kind of analysis. As I said at the beginning, have always thought that the key to understand this interesting, complex legal system in which the Qadi courts function alongside the Siyasa Council lies in this thing about forensic medicine. In modern Egyptian Arabic, as in Egypt as much as elsewhere in the Arab world, forensic medicine, now, does anyone know what its name is? طب شرعي. Shari'i medicine. In other words, sharia-driven medicine. Shari'i is the adjective of sharia, so it's shari'i, sharia medicine. But in the 19th century, it's not called sharia medicine. It's called siyasi medicine. It's called طب siyasi. So my question was, what is this طب siyasi? Who are these doctors I mentioned in the beginning? And I traced them, I tried to identify them. This is a painting from the Egyptian Medical School, a museum of the history of medicine, depicting what is believed to be the first dissection lesson in modern Egypt, 1829. I wanted to know who these students were, who this doctor was, and what kind of training these men got as physicians. And I'll spare you the details, but I particularly zoomed in on their role as coroners. And you see here, this is a small parchment, a small piece of paper, not bigger than a palm. This is, for me, the quintessential sign of the modern state. This is a sign of so much confidence and power of the state. Do not mistake how small it can be, because what this is a burial certificate in which the coroner is identifying the cause of death of people who died in a particular neighborhood. That, and at the end of the month, they are tallied in a register like this that gives the name of the dead person, what he died or she died of, the age, the location, the residency, and the religion and ethnicity. Now, this is basically vital statistics. This is how the state collects vital statistics. A state that can collect, identify the cause of death of every single person living on its realm is an enormously powerful state. And a very important linchpin in all of this is these coroners, is these doctors. It's the doctors that we read at the very beginning of the case, the Muhammad Abdurrahman case, who when there is foul play, they do not really say it's diarrhea. They give a detailed account of what caused death to say that it was based on, that this was not a natural death, that this was death. Now, so this is the medical part, which can be a subject of an independent lecture in its own right, but I'm just telling you how complex this medical part is. Now let us bring them together, the medical part and the legal part. Let us see what actually is taking place here. And to explain it, and this is really the key idea, this is the key question here, that this is not a modern case. This is, as you can see, 1595. This is a typical account of a sharia register in which medical expertise is actually called upon. But what we see in the 19th century is very different. What we see of how medicine was applied in the 19th century in criminal cases is very different, especially in homicide cases. Now, the logic is the following. Despite, contrary to what Oda has said, this guy we said at the beginning, the guy who was executed by Nasser, Sharia fiqh actually was not born complete, and it is not sublime, and it does not have answers to everything. In fact, fiqh has serious shortcomings and serious problems when it comes to homicide. Specifically, homicide in Islamic fiqh is dealt with as private law, meaning that it is the family of the deceased who should initiate legal action. They are the ones who go and initiate legal action in the court. They are the ones who also bring witnesses and establish legal proof. This is the first point. Second, legal proof is very difficult to come by. In homicide cases, as I said, you either have a confession by the defendant or two witnesses by two upright male witnesses whose testimony has to be exactly the same. So if one of them says, I saw him stabbing him in the neck, and the other one said in the shoulder, then the judge is enjoined to drop the charges based on the hadith of the Prophet, drop the charges in case of doubt. So if there is any case of doubt, do not pass a judgment. And of course, most murderers do not confess unless they are stupid. So as a result of this, Ruud Peters, in this book, has an amazing statistic. He made a sample of 1 year in the 18th century, can't remember which year. He went to one sharia court in Egypt and looked into all homicide cases adjudicated by that court, and found that out of all of these cases, only 5% of murder cases received a death sentence. Why? Either because it was impossible to prove, because there was no witnesses, and because there is no confession, or, and this is the third problem with fiqh when it comes to homicide, that the next of kin, that is the family of the victim, can also choose the punishment. They can insist on capital punishment in the case that, that they manage to actually provide, the very few cases in which they manage to provide proof. They can still say, we don't want capital punishment, we're ready to accept blood money. Or they can pardon the victim, the perpetrator. So because of this, capital punishment is hardly ever applied, passed by a judge. And in the few cases in which it is passed, the next of kin can forego it and say, no, we prefer to pardon the murderer instead. What does this mean? It means that society, not the individuals, not the family of the victim, but society has no deterrence to a crime as serious as homicide. And from that, there has always been, from day one of Islamic law, a need to supplement fiqh that is applied by the Qadi in his court with something else. And this is called siyasa. And siyasa is based on the right, first of all, it's based on the right of the ruler to pass qanuns, to pass legislation, not based on fiqh. But they're not secular. They're not Western. They're not French. This is before France was invented. We're talking about 8th century, talking about 9th century. All Muslim states legislated, passed legislations. In the Ottoman Empire, it became very famous, became called Qanun. But they also had other bodies. Sometimes they call it mazalim, Diwan al-Mazalim. In Egypt, it's called Majalis al-Siyasa, Siyasa councils, the aim of which is to apply this Qanun in homicide cases. And these Majalis would not insist on witnesses. They can use circumstantial evidence. And the best example of circumstantial evidence is forensic medicine in the 19th century, hence its name. Hence it is called siyasa medicine. It is basically, it's legal medicine. It's what we call forensic medicine now. It is legal medicine, it is medicine, medical evidence supplied for legal purposes. So let me just end by going to our case one more time. So typically, what would happen? A case like this is actually adjudicated simultaneously by the Qadi in his court and by the Majlis according to siyasa. If the Qadi finds for the defendants, in a very few cases, and actually manages to establish proof, and passes a qasas, which is death sentence, then of course that's the end of the story. But what if he passes qasas sentence and the relatives of the deceased prefer blood money? Or what if he could not establish legal proof in the first place and he could not pass a qasas punishment in the first place? What if the victims, the relatives of the victim, drop the charges altogether and pardon the killer? Here, the case goes to the Siyasa Council, and it is adjudicated according to different principles. Not the insistence on verbal acts of a confession or an eyewitness account, but circumstantial evidence, the most significant example of which is Siyasa medicine. And on the basis of that, and the basis of Qanun, as we see, not a death sentence, a prison sentence is passed. So that the heinous crime of homicide will have some kind of deterrence. So that the killer cannot literally go away with his murder. The last thing I would add is that, as you can see now, this is the logic of these councils. The councils of first instance, there's appellate councils, and then residing over all of them is this thing called Majlis al-Ahkam, the Council of Ordinances, in which all homicide cases have to go to be ratified by that council. This council is not manned by jurists. They're not Muslim, Islamic jurists. They're not fuqaha. They're not ulama. They are administrators in the state. But they're administrators in the state who apply qanun. And this qanun is not secular. It's not French. It is part of siyasa, and this siyasa, actually, its name in Islamic, in the Islamic discursive tradition, it's called siyasa shari'a. It's shari'i siyasa. So this siyasa is actually part of sharia. This is why I said at the very beginning, sharia is not fiqh. Sharia includes many things. It includes qada, which is the practice in court. It's not just the verbal, the mental, intellectual activity of the fuqaha, but it's also what the qadis do in court, but also siyasa. So siyasa is an integral part of sharia. And I will end with, not this is the cover of my book, but this. This is a fascinating coat of arms of the Ottoman Empire at the end of the 19th century. Significantly, you see on the left a balance. This is the law. This is the legal system. And this balance has two books. Not one, but two books. One green and one red. And that is what law is. In Islam, there is always fiqh in green and siyasa in red. This is not an innovation of the 19th century. This is not a bid'ah that is a result of secularization. This is an integral part of what Islamic law has always been. We have a distorted understanding of Islamic law because we have reduced sharia to fiqh. And we have accepted uncritically what Islamists have been telling us, that this fiqh is sharia. But if you look at the history of legal practice, not legal thought, legal practice in courts, and not only in the qadi courts, but also in the siyasa councils, we have a much more complex picture of how sharia was applied throughout history. And what I shared with you today is one particular example, which is 19th century. Here, sharia was not applied through codification, which is the obsession of Islamists. Let us pass new laws. It's not only by codification, and it's not only by applying qasas or hudud or fiqh, but by coupling sharia, by coupling fiqh with siyasa. Thank you very much.
Thank you so much, Professor Fahmy, for an utterly impressive and thoroughly convincing presentation and lecture. I am positive that my colleagues and our students and the audience have thoroughly enjoyed your lecture as much as I did. I've been thinking about some questions and comments. However, I'm not going to abuse my power as the moderator, and thus I would rather turn it first to our audience to share their questions and comments with you. So we have around 20 minutes or so for questions and comments from the audience. You can direct your questions directly to Professor Fahmy. We do have a mic right here. Okay. And then, so would you like to take questions, a round of questions, or one question?
Let us take one at a time first, and then we see how it goes.
And then you pass it to Sarah.
Thank you again for that, Professor Fahmy. And I wanted to ask, regarding to this label right there, you said it's a mix of sharia and, I think, politics, right?
No.
Fiqh.
It's a mix of fiqh and siyasa.
Siyasa, right.
But siyasa is not politics.
Well, the type of law where there's like different rules under that than sharia, for instance, right?
No.
All right, so.
No, it's very good you're saying this, because my whole point is that we make a distinction between fiqh and sharia. So what we're seeing here is a combination of fiqh and siyasa. Together they make sharia.
So in English, how would you say that? What is fiqh?
Fiqh is jurisprudence.
Okay.
Is intellectual. It's the intellectual product of the jurists, and it is best translated in English as jurisprudence.
And then the other part is
Siyasa. Siyasa is a difficult word. Why? Because all of these words have acquired new meanings. Like you said, you instinctively said it's politics. I instinctively, it took me 5 years to figure out that in the archives, Majalis al-Siyasa are not political councils. They're something else. Why? Because the word siyasa used to have a certain meaning and acquired a new meaning at the end of the 19th century.
All right, thank you.
But does this answer your question?
It does, because I thought, you're saying sharia, but they both have kind of the same rules under each one, right?
No.
They're different. See, that's my question, how do you find the balance between them if they have kind of different
That's
laws?
a very good question, yes.
Okay.
The balance is tense. So let me again summarize. In a qadi court, in a homicide cases, he cannot accept circumstantial evidence. He has a contested act. We don't know who killed this person. I don't know. I am a judge. I don't know. I was not on the site. So how does the truth of this past act is to be transmitted to the court? The fuqaha, the jurists, from which the word fiqh comes, the jurists have insisted that there be trustworthy carriers of truth. And what better carriers can there be than a confession? If someone confesses, then, and of course, uncoerced, unforced, so there's no torture in a qadi court. And there are strict regulations and conditions and formulae that the confessor has to utter, not once, not twice, but 3 times. So that he actually insists, I am the killer, and I killed in this way, for that purpose, on that day. He has to repeat it 3 times in front of the qadi, for the qadi to accept and be confident that this actually is truth. Otherwise, he has to, if there's no confession, rely on 2 witnesses. Not any witnesses, not any male witnesses, but male witnesses whose reputation has been upheld year in and year out. So if witness A is discovered to have been lying, or last year we've been seeing him eating in Ramadan, or that he beats his wife, then his testimony is not to be accepted. Assuming the probity and the reputation and the upright standing of both of them is established, which is what the Qadi does, then he has to make sure that the testimony is congruent, is exactly the same in all details. When he accepts this, then he can pass a qisas ruling. The siyasa doesn't do this. The siyasa accepts circumstantial evidence. Someone fleeing from a murder scene with a dagger, dripping blood, and we see a body lying behind. No one saw him stabbing, but most likely it is him. So we pass a sentence based on this. The fuqaha would say, no, there is 1% possibility that he is not the killer. Those of you who know your Agatha Christie, there is actually one of her stories, the ABC murders. It's exactly this. Someone picks up a dagger, he thinks he's the killer, but he isn't. He's been implicated, he's been framed. And the fuqaha are aware of this. They say, we cannot be certain. The Siyasa Council says, we cannot be certain, yes, but we can be suspicious. And we will rule on suspicion. So it's 2 different philosophies. One upholds the right of the individual. The other upholds the right of society. They are informed by different principles and are taken to different directions, and there is tension between them. The fuqaha never trusted the siyasa councils. They would look down on them and they say, you're stopping. And the siyasa councillors are looking at the fuqaha and telling them, you're just too bookish. And you're not concerned with the well-being of society. And you let killers off the hook. So there is tension, but that is what sharia is. Historically.
Thank you. That answers my question.
Hi, how are you? So, my question is, you refer to Prophet Muhammad, may God rest his soul, to drop the charges in case of doubt. But then, do you think this idea still exists even here when they say, proven until, you're innocent until proven guilty, which also came from the Bible, which stated that, like, you cannot basically depend just on one witness. This also, I feel like all law, do you believe that all laws initially came from religion?
Well, religion is this is a very important question. The argument that somehow modern law has been devoid of morality and ethics is also not completely true. And it's not necessarily traces like the ones you're trying to establish between a Quranic or a biblical verse and the actual text of the law. It can be the philosophy of it, the spirit of it. And I have a student who is actually working exactly on that. He's working on the 20th century Egyptian laws, and he's saying it's not true that they're devoid of morality, the way we've been led to believe. The text, but the practice of the Qadis in present-day Egyptian secular courts, they too are informed by principles of ethics and morality. How you go about establishing and showing this is a very important question. It takes various forms. What you're hinting at is only one form, which is we see a biblical phrase or a Quranic verse and try and see its resonance in legislation. That's a very valid way, but it can take various other forms as well.
Professor Fahmy, you've been doing an amazing job explaining in the lecture. So maybe I will ask you, because you looked at me when you talked about Agatha Christie, and I felt a bit offended. I shouldn't be the only one who knows who she is.
I saw you smiling, so I said, okay, you.
Yeah, I was an avid reader of Agatha Christie, but she was right, you know, but yeah, she was an amazing. She wrote novels, suspicion novels, and she was very well respected and known among the generation of the 80s and even the 70s. So questions? Do we have? Shane?
Hello, Professor.
Hi.
Thank you for the presentation. It was very highly informative. I enjoyed it. My question is, in the English common law, there's the system of jurisprudence of the courts, but there's also codifications by the legislature. And on occasion, these, usually they work together, but sometimes they conflict. Do you see parallels between this system of English common law and these sort of two systems of law and this 19th century Egyptian system that you've described in your lecture?
Yeah, this is a wonderful question. I think basically the question about how typically the Egyptian laws are the positive laws of the Arab world now are typically compared to the continental system rather than the English common law system, where there is like the Napoleonic Code, there is a code, and but as you're pointing out, there are systems in which these coexisted. There is a code, and then there is the precedents established by the courts. And then we have the jury, which we do not have in Qadi courts. We have the community acting as part of the whole legal system. And I think these are very useful comparisons to try and see what common law traces one can see in sharia in both its wings, in the siyasa and in the qada, in the fiqhi part and in the siyasa part. And I would say that the fiqhi part, the one we see in the qadi in his court, is more akin to common law, and the one we see in the siyasa councils that is based on codes is more akin to the codification, the positive law system that we see, especially in 19th century France. What I am now fascinated by, something I didn't really talk about, is the jury. Because we do not have a jury system, it is true, in the Qadi court. But believe it or not, the community is very much present. There are elements now we see of the Qadi relying on what is called in English translation, the court witnesses. Shuhud al-udul. It is the shuhud, the witnesses that can help the Qadi identify people and can be, in a sense, the representatives of the community in court. And now that that is historians working on the Ottoman Empire for the past 50 years, I have to tell you how significant this is. You know, about 50 years ago, the registers of Sharia codes have been discovered. In the National Archives in Istanbul, in the National Archives in Egypt, we're talking about thousands and thousands and thousands of registers with millions of cases covering at least 5 centuries. So it's a huge volume. Initially, historians, please have a seat. Historians were interested in these sources, in these documents as sources for social history. How women went to court, the institution of the family, economic history, prices, and so on. But lately, they've been interested in it as sources for legal history. So that now we understand Islamic law not only on the basis of the fiqh manuals, but also on the basis of the registers of legal practice in these Sharia codes. And accordingly, we discovered how important these people, mostly men, played. Every qadi applies fiqh, but he also relies on upright members of the community in initiating the procedures in the court. And their names and signatures are included in most cases, so we can actually identify them. They are not necessarily the wealthy people, but they are the upright, mostly men, only men of the community. And I think they are the ones who really look over the shoulder of the Qadi to make sure that he is a good Qadi. He does not accept bribes, and he's not corrupt, and he knows his law, and he adjudicates properly. It's not the same as the jury, but it makes you think that the Qadi court is actually not only God's court or the Qadi's court, but it's also the community's court. So this is not a direct answer to your question, but I'm trying to share with you some ideas and thoughts about how we are engaging with questions like yours. What kind of law is this? Is it common law? Is it a positive law? What is it? And it is these sources that can help us have a more complex understanding. Again, we should not reduce sharia to jurisprudence, to the manuals and the tomes of the fuqaha. It is much more complex than that. And now we have the sources to allow us to flesh it out.
I have a final question.
Thank you, Professor.
If more,
Thanks.
questions from the audience.
So, Professor, you put forward a very nuanced understanding and definition. And I know a little bit of, I know some of the answer to my question, which is why don't we have this nuanced understanding more resonant with our societies? Why, when we talk about sharia, then it is often and always equated with, okay, we're going to be sending women back to the house, that in the West it's the Muslims are coming and you need to be afraid and you need to be wary. How come that we do not have these nuanced understandings being more prominent and more put forward and pushed forward in our public debates and our policy debates about what is sharia and what is not?
I would like to say that because we don't have a historical understanding of it. I am as you pointed out, I started with economics, and then I moved to political science, and then, as I always like to joke and say, I eventually saw the light and became a historian. And I really think when we read the history of not other societies, our Muslim societies, we have a more complex and nuanced understanding of how generations of Muslims before us have dealt with these questions. How do we really find an answer to homicide? How do we apply sharia? And to be humble, that we are not the first to confront these questions, and to dislodge ourselves from this very privileged position of thinking that because we are in the 21st century or the 20th century, we know best. And I'm not saying let's go back to the time of the Prophet. I'm saying we have 14 centuries to learn from. Why do we have to believe that we are better Muslims than 15th century Mamluks? Well, not necessarily. Now we have the records, let's look at them and let's see what they have done and enrich our understanding. I think these are ultimately highly polemical debates. And for me, the way to avoid polemics is to go to the archives, and be humbled by them. I want to end maybe, yes, Lynn.
Please do, yeah. Actually, I have a question that is very much related to the last thing that you said. I'm a historian of the early modern period, and I'm actually wondering, because you've been talking about the historicity of this subject, how far back do we have sources right now that we could study this topic? Mamluk period, or do we have anything earlier? Or?
No, this is a wonderful question because it's about sources. What we have, I have been lucky to find basically an archive. I found an entire archive of this legal system. In previous moments of what I consider to be equivalent systems in other countries, in other periods, we don't have archives. What we have are explanations of that system, sometimes by practitioners in it, historians who happen to be members of these councils, so they describe to us what they are. Sometimes archaeological. If you go to Delhi, if you go to Istanbul, in these palaces, these big, in Delhi, the big fortress, there is Diwan Humayun. You can actually see where the Qadi, in this case the Sultan, would actually sit to adjudicate cases, not based on fiqh, based on his own law. But we basically have not records, but the accounts by historians, chronicles, and sometimes descriptive and prescriptive accounts of what takes place or should take place in the Sultan's court, as sometimes it is called. But what we have in the 19th century in Egypt, and we're discovering also in the Ottoman Empire, is a unique thing because it's been preserved.
I have many, but I'll just ask one about the Meclis.
Yeah.
So you mentioned that it had different names, and I'm assuming in more Western Ottoman parts of the Ottoman Empire it would be divan.
Yes.
So where in the system, or how far back in the sort of administrative system does this go? Do you know any of those? So like provincial and urban, or?
It's only now that we are starting. I mean, a good source would be Bashar II, her book on sexual crimes in 18th century Ottoman Empire. She relies on that Divan Humayun, of how the Divan Humayun had managed to adjudicate cases like this outside the Qadi court, in parallel with the Qadi court. James Baldwin, who teaches in London, also has a book based on Egypt, but an earlier, 18th century, and comparing the records from Egypt with the records from Istanbul about these kinds of cases. So it's only now that we are about to flesh it out. I want to end maybe with one. Okay. I have a few pictures that I want to share with you on this system. Actually, photographs. And as it happens, it's a famous photo essay. It's not from Egypt. It's not the 19th century. It's actually Iran. It's Iran in 2015, a few years ago. And I discovered it in The Guardian. It's a famous story that became famous because this photojournalist has documented exactly what I'm talking about. A murder case, which two adolescent boys, not adolescent, but two, in the early 20s, men fought with each other, one of them killing the other. And the mother and the father of the victim took him to court. The court took many, many years. Eventually, the Qadi, Islamic court, this is the Islamic Republic of Iran, passed a qisas sentence, a death sentence. And that is the day of the execution of the, after 10 years, this is the day of the execution. So the village is gathering together, and this guy, and his name is there, you can see Arash Hamouchi, that's the, Hamouchi is the journalist who became very famous because of this photo essay. And they bring the killer, and they put the noose around his neck, and the person who actually literally has the right to kick the chair from under his feet is the mother of the victim, because she has it, not the state, not society. In Arabic it's called awliya ad-dam, those who own the blood, the shed blood of the victim. It's his heirs. And in the crucial moment, she comes in, and this is her husband, the father of the victim, to her left. And instead, she slaps him on the face. She pardons him. And in Western journalism, that story became known as the slap of forgiveness. And of course, the whole community starts clapping and applauding, and the killer's mother goes down on her feet to kiss the feet of the victim's mother for pardoning her son and sparing his life. And it's a beautiful story of clemency and magnanimity and generosity, and indeed it's only after this moment that closure can be done, that she can now go and visit her slain son with her husband, and finally actually receiving visitors and accepting condolences. She could now, not by killing the person, her son's killer, but by pardoning him, she could have closure. Usually, this is how the story ends as far as Western journalism is concerned, because it's a Hollywood story. But that is not really how it stops. It actually stops with the killer going to prison. That is siyasa. He does not walk scot-free. He'd been pardoned by the mother, but the family, but society does not. The state, and this is not a secular state, this is the Islamic Republic of Iran. The state has a stake. The state does not let murderers walk scot-free because the private parties have settled their dispute with each other. That would not be a legal system. That would mean chaos in society, because it would mean that murderers can literally walk away with murder. There has to be a punishment, and in this case the punishment, as in my case, was prison. Thank you.
Thank you so much, Professor Fahmy. Very profound, and thanks for the Department of Political Science and for the Center for Security, Race and Rights for co-sponsoring the lecture. Again, thank you. That was very profound. Huge thanks to our speaker and Professor Khaled Fahmy, and to the audience. Thank you again. Thanks.
Thank you.
I saw you here, so just write a little. No, don't worry. You can just write a little something and send it. Whenever you can. I think the sooner you sit down and write something, the better for you, but you can do it